Are you confused about the BOI reporting rules in 2026? Let's clarify that. In 2026, if your business is formed in the United States, you are in luck. The latest FinCEN rule now exempts these US-formed entities from federal beneficial ownership information reporting. This is a significant shift from previous guidance, which led many businesses to believe that all LLCs and corporations must file. This change comes from the March 2025 rule, where FinCEN refined the definition of a reporting company. Now, it primarily affects certain foreign entities registered to operate in the US. So instead of asking, does every LLC need to file BOI, the key question is, was my company created in the US or overseas? Regarding your compliance responsibilities, this article does not serve as legal advice. Always consult qualified counsel to confirm your company's duties. Let's break down the critical updates. On March 21, 2025, FinCEN removed BOI reporting for US companies. The updated rule applies solely to companies formed under foreign laws and registered to do business in the US. This means if your LLC or corporation is US formed, you are exempt from BOI reporting. Now, what about businesses that still need to file? Foreign entities formed under the laws of another country may still have to file if they register in a US state and do not qualify for any exemptions. Next, we need to discuss crucial dates. If a foreign reporting company was registered in the US before March 26, 2025, they needed to file by April 25, 2025. If registered after this date, they have 30 days from registration to file their initial BOI report. You might wonder how to determine if your business is considered domestic or foreign under BOI purposes. Remember, being foreign does not mean formed in another US state. It refers to entities formed under foreign laws. For instance, a Texas LLC doing business in Florida remains a domestic entity for federal BOI purposes. Conversely, a business formed under Canadian laws registering in a US state would be classified as a foreign reporting company. Additionally, BOI reporting differs from state-level disclosure rules. States can have their own requirements, such as New York's beneficial owner disclosure regime, that takes effect on January 1, 2026. To avoid common mistakes, here are a few tips. 1. Don't assume that all US LLCs need to file. 2. Remember that foreign entities are those formed outside the US, not just out of state. 3. Review older compliance materials as guidelines may have changed. 4. Understand the differences between various compliance items to avoid confusion. 5. There's no fee for filing directly with FinCEN, so be wary of scams. If you're still uncertain about your BOI obligations, follow this practical checklist. 1. Verify where your entity was formed. 2. Check if it was under US or foreign law. 3. If foreign, check if it registered in a US state. 4. Determine if an exemption applies. 5. Review filing deadlines based on registration dates. 6. Analyze state-level disclosure rules and requirements. Understanding these changes is vital for registered agent and compliance workflows. If you're operating across states or with international structures, clarifying your BOI status becomes even more critical. In conclusion, if your business is US formed, rejoice. You are likely exempt from federal BOI reporting. However, always stay informed and proactive about compliance to avoid pitfalls. Need assistance? Rapid Registered Agent is here to help you maintain compliance and manage your registered agent responsibilities efficiently. Get registered agent service today.